everyone, welcome to the 21st session of the SOGICA conference. We are having amazing time for the last 3 days. I'm really grateful to the SOGICA team, all the volunteers and all the speakers, panelists and attendees. We are now almost towards the end. After this last parallel sessions, there will be a keynote speak at 4:30 UK time, so don't miss that. And please stick after the keynote as projects recommendations will be published. So that exciting things are still on the way on the last day of the final SOGICA conference. So today we have 2 speakers, and before I introduce them and give the floor to them, I'm going to remind you 2 things. This session is being recorded till the end of the presentations, and the question and answer part will not be public, but all the conference videos will be available online. You or your names are not visible in the recording, so no worries about that. And please write your questions when it comes to your mind during the presentations, and I will ask them to the speakers during the QA session. Yeah, so our first speaker is Amandine Lebelle, and she is a PhD candidate in political science at the University of Trento and Sciences Po, Paris. Her thesis analyzes how the politicization of gender and migration has contributed to the reorientation of the EU Common European Asylum System to include LGBT plus identities as an asylum category. And she's going to be talking about the same topic, a gender-sensitive securitization of the Common European Asylum System, the EU list of safe countries of origin and its impact on LGBTI plus asylum seekers. And I give the floor to you, Amandine. Thank you.
Thank you very much, Emre. So I'm just going to share my screen as I have practiced. All right, so you can see it. Here we go. Is it okay? All working? Perfect. All right, so thank you very much, everyone, for attending this panel, which is one of the very last panels of the SOGICA conference. And so I'm going to present to you my part of my work of my PhD, which is on the Common European Asylum System. And today my presentation will focus more specifically on the EU Common List of Safe Countries of Origin, which is being discussed at the EU level right now. So just maybe to start with some elements to help you understand better this issue. So a safe country of origin, it's a that has been developed in the late 80s, 90s in Europe. And basically it designates countries where basically there is a democratic system, there is some form of like justice that is being ensured, there's globally no persecution, no threat of violence, so people from that country are not supposed to be seeking asylum. And the objective of making such list is basically to deter bogus asylum seekers and to accelerate the processing of claims, because you have all the claims are fast-tracked and you have some limited procedural safeguards, like you have less time, for example, to prepare for the interview. Sometimes the appeals are not suspensive, you don't have access to material conditions of support, etc., etc. So the countries that are on this list are, for example, Senegal, Ghana, Albania, so democratic countries that are producing refugees, of course, but where there are still many issues for LGBTI people. And today, in the context of the ongoing reform of the Common European Asylum System, there is a will which has been announced by the Commission to introduce some form of compulsory list of safe countries of origin at the EU level. So basically my question was, how are gender and LGBTI related concerns included into the EU's approach to border and to regional security in the case of safe country of origin lists. And these are a few pictures about the French context, where you can see very different types of organizations, the BAM and VRDIS, being opposed to such lists, and with very vocal oppositions to their implementation. So in terms of methods, very quickly, it's a political science research that I was saying. It's part of my PhD, and my research was based on text analysis of EU-level documents related to the notion of safe country of origin since the 90s, but also with a specific focus on the ongoing reform, and also on a selection of 24 semi-structured interviews with organizations supporting asylum seekers in European countries. So the idea was not to get a really in-depth knowledge of specific countries, but just to grasp the European picture and what a common list would mean in this context. So first, to give you some elements of introduction, as I was telling you, the concept of safe country of origin was first developed in Europe in the late 80s. And the first real occurrence of this notion being implemented into law was Switzerland in 1990. Then it quickly spread around the continent, as you can see. So this is a map that I've made. It's a compilation report where you have the first instance of introduction of the safe country of origin concept into national law. And then the color indicates how many countries there are on this list, knowing that some countries also put EU member states as safe countries. And I've withdrawn that just for the sake of comparison, because otherwise you have plus 30, like plus 27 countries on the list. So as you can see, you have some countries where you have up to 25 non-EU member states that are on those lists, and in others, you have like Finland, for example, or Portugal, you don't have any country, right? The first appearance of this concept on the European agenda was in 2000, during the first discussion around the Common European Asylum System, which is a system supposed to harmonize asylum practices. And it's really linked to the notion of like first securitization of asylum and then Europeanization of migration. So with, first the idea that migration and asylum are security concerns, which is not necessarily something supernatural, but it's also something that has been constructed at that moment. And the idea that if you want well-working security policy, you need to have some form of European cooperation. However, I really don't think that we can say that the spread of safe country of origin practices was all the fault of Brussels, because it first happened through intergovernmental cooperation that was with unaccountable meetings by security actors that were done all around the EU and in Europe in general, and where those concepts were being discussed. Still, the negotiation around the Common European Asylum System were really crucial in tilting the balance, because first, they gave a legitimacy of the concept in the European order, and you can see a second wave of countries implementing this concept at the beginning of the 2000s. And then also we passed from a sort of like horizontal will-based harmonization to a vertical enforced and compulsory one. However, in the 2000s, they agreed on the fact that this concept was into European law, but they didn't agree on what country. Very, very quickly, because it's part of, I don't have some time to talk about it here, but it's still an element of my conclusion, so I need to talk to you about it. It's interesting to ask yourself, where does safe actually comes from? Because at that moment, you had the United Nations Development Program, which had developed the idea of human security, which was a much broader and encompassing conception of security, as encompassing environmental security, economic security, political security, etc. Still, it's the term safety that was used, and you actually see a proliferation of this term in the late 90s. And it was often used as a sort of like empty receptacle and French cachetex So concealing something at the same time very central and very shameful for security policies, basically, because it puts the accent on what the asylum seeker is supposed to have, safety in the country, and not what on the policies actually do to them, which is securing borders and security. And what is important with those terms is that safe countries, like it entails that some asylum seekers are unfit for the EU, that they shouldn't be there because it's okay in their country, basically. And what you can see in this table, which is the list, the first draft of the common EU list of safe country of origin, you had many of those countries that actually, criminalized or still criminalize homosexuality, just to talk about the legal background. And many of those countries actually produce some asylum seekers still today. If we take seriously the idea that security is not only about describing situation, but that it also organizes social relations, this idea of like presumed safe countries, it really structured the relationship of state to some asylum seekers that are just marked as abusive or bogus, for example. So it's a paradox of the first SEAS package with the protection of LGBT people, which was first implemented at that time, but an overlapping of the geography of safety and state-sponsored homophobia. So LGBTI people basically were kind of excluded from the evaluation of the situation in the country of origin, and thus of the conception of the polity more broadly. Today, there has been new debates as to develop a EU common list again, and you can see that there has been also parallelly to that a renewed place granted to gender in the Commission proposals. So it was also increased by the Parliament's amendments. So the first mention of safe country of origin, which is recital 18, actually states that you need to take into account the complexity of gender-related claims. So it's really the first mention, it links it directly to gender and sexual orientation. You also have other procedural guarantees like training, interpreters, these kind of issues, and a broadened understanding of gender as to women, of course, but also LGBTI people, and intersex people were not taken into account in EU asylum legislation so far, so it's a big change. Still, when we look at the procedure directive right now, we can see that parallel to this gender sensitivity, there is a harshening of discourses on safe country of origin, and also a sort of like semantic slide between what is actually, I mean, a personal characteristic. I'm French, for example, cannot do anything about that. And abusive behaviors, abusive again, because those are, I mean, so a whole set of behaviors that are seen as abusive. So here you can see in the quotes that you have safe country of origin together with false information, inconsistent or false representation, clearly abusive, manifestly unfounded claims. So really a slide of all, like a semantic slide of safe countries are just, you know, unfounded applicants. And also what is interesting to note is that the concern for gender just disappears between the recitals, which are non-binding. So recitals are at the beginning of the text and they are non-binding, they have interpretative purpose. And the provision, which are legally binding, they don't have those elements of gender anymore, or not as much in them. So it's really sort of like designing harsh policies, and then you ask the governments and the humanitarian actors to actually like smooth out, let's say, the sharper edges of these policies, but it's up to them, up to their goodwill. So concretely, in terms of impact on LGBTI asylum seekers, my question was first, you know, what is the impact? And then the second one was, if we implement gender-sensitive safeguards, does it actually allow us to compensate for such security-oriented measures? And what appears from my field work is that it's not really the case. Even so, the issues I'm going to talk about are very much visible in countries where you have those lists without any gender-sensitive provisions, but it also marks countries where you have those provisions, and even sometimes countries where there is no safe country of origin list, because oftentimes you have sort of like unofficial safe country of origin lists that are just on the adjudicator's mind, and that's how they also judge the claimants. So I've identified 4 categories of consequences. First, moving backward, so reinserting practices that are supposed not to exist anymore, even though we know that they still exist, like discretion requirements. Oh, it's globally safe, so maybe you can just be a bit discreet. Basically, that's the idea. Exacerbating already existing issues, so I'm not going to talk so much about that because the conference has been quite a lot about it too, but credibility, late disclosure, and basically the idea that you have shorter time frames, and you're not supposed to be disclosing your sexual orientation at a later time, because then you're also falling in the category of manifestly unfounded claims. So it's very complex. It's also legitimizing and institutionalizing previously informal practices. So for example, you have sort of like informal lists with no accountability in some countries. Like if you're from this nationality and you have LGBTI-based claims, you won't get the refugee status, and that's it. And also dehumanization of claimants who are just seen as their nationality. And finally, more worryingly, but that's still more hypothetical because it's not so common, but it's starting to appear, some new restrictive practices that are happening, such as, for example, neighboring safe country contamination, where I've heard about cases of asylum officials actually contacting officials from the country of origin to check where the applicant was exactly living, because they were suspecting that he was from the border, but the border where there was a safe country of origin, and the applicant was saying, no, I'm from the other side of the border, the non-safe country. So you can see here suspicion that is spreading beyond the borders of so-called safe countries. Okay, if we have a closer look at the EU, we can see today that there is a global improvement of consideration of LGBT plus issues in this list. First, because no country on the list criminalizes homosexuality, which is already a good change, and sometimes even have like good anti-discrimination legislation, better scores than some EU member states too. But what is interesting to me is how the Commission acknowledges the presence of violence against LGBTI people in all the safe countries of origin on the list. So it's really, I think, the question of who is deemed representative enough actually as to assess the global safety of a country. And it's clearly not LGBTI people, it's not women either, even though it's still the majority of humanity, it's not children sometimes, it's not Roma people, etc. Because those people are really put back towards their difference, which is seen as like irreducible, and they are not considered as like the universal citizen to which when we take into consideration when we assess safety of a country. And also in all of these countries, I've heard about organizations with asylum seekers coming from these countries, so you cannot really say that it's super safe, even if there are anti-discrimination legislation, of course. So despite those new discourses on gender and LGBTI friendliness as integral to European identity and the use of gender sensitivity words to counterbalance those security-oriented policies, you still see these former logics of exclusion of LGBTI people that resist and pervade the logics of border securing. So I think that we really need to nuance the idea of gender-sensitive nationalisms. It's, of course, homonationalism, femonationalism are very important concepts, but we also need to think about continuities that can happen between very different discourses, and not only about ruptures too. Okay, so just very quickly, a third part, it's more a bit exploratory, but I think it's still very interesting. The organizations that I have interviewed, they do use the concept of safety quite a lot in their discourse, but they tend to adopt a definition of this safety that is just totally different from the one present in legislation. It's much more, it's closer to the UNDP concept of human security, actually, than to the one of safety. Because in their understanding, safety means also freedom from persecution, rights to health, legal gender recognition, dignified living condition. It's a positive definition of safety, not only a negative one. It's not only freedom from persecution. And you can see in many countries, the development of hybrid and sort of ad hoc practices of contestation of the notion of safe country. So whether it's contesting non-EU countries as safe, by sharing jurisprudence from different countries and showing, okay, in this country, the judge said that it's not safe, so maybe we can use it. It's contesting other EU countries as safe when appealing Dublin transfers, for example, saying, okay, no, the asylum seeker cannot go back there because it's not safe for this person. And it's also contesting one's own country as safe, because to be able to say, okay, it's not safe for this person to go back there, you need some reports, you need some letters from organizations, and often organizations actually do produce the documents on how the country is not safe for LGBTI people, which is very interesting. So this recurrence of discourses and practices make you see a sort of like Europeanization from below to below, of discourses, of these counter discourses on safety that actually uses established networks facilitated by the EU, but really bypasses the EU institution themselves. And it's more like practice oriented than advocacy. To conclude here, because I have 2 minutes left, I was wondering if this counter discourse can actually, have an impact on EU institution. And at first you have sort of a good potential because you have an opportunity window, because collaboration with the civil society actors is actually very important for EU institutions. You have some instruments to access this EU level with all, for example, the NGOs and coalitions that I have put on this slide. And also in terms of forms of advocacy, those organizations are very often used to produce discourses that are acceptable for institutions, because they are actually collaborating very often with the asylum institution in their own country. And still, it's not super central at the EU level. And I would say, and then I move to my conclusion, I promise, that this failure comes from the fact that we don't have a real collective mobilization so far. It's more like a loosely bound network rather than a structured one with a collective sense of belonging. And the lack of collective sense of belonging is kind of an issue, because if you do not make sense together, if it's, I would say, still too embryonic among organizations, it's very difficult to actually produce a coordinated discourse. So many organizations have a representation of the EU in normative terms, like human rights are important to the EU, and not in strategic one by saying, okay, the CEAS does this or that. You also have a great level of unawareness of the ongoing CEAS reform, which is very worrying. Discouragement linked to the feeling that the EU is not really accessible, and the complexity of working with the diversity of organization, of course. So it's a counter discourse, Europeanized, but with little impact on EU politics so far. To conclude, to my conclusion, which is basically, can security be gender sensitized? I would say that there are 2 interrelated answers. First, there is the question of the division between security and safety. And in my opinion, we cannot really say that security is becoming super gender sensitized. It's more the concept of safety, which is blurred and undefined, that is being so. So beyond recitals, you have no real question of what securing borders actually means in terms of human rights and gender. You also have to underline the continuities between traditional conception of the community and the nation and the new gender LGBTI-friendly ones, and these older logics still pervade the recast of the reception directive. And LGBTI asylum seekers are really disproportionately impacted by SEO practices. That's what the organization have reported me. So that's another issue. Then the last question is like, is the EU doomed to fail LGBTI asylum? And I would say not necessarily, because the EU has been really a key normative actor in LGBTI protection in some countries. And you have all the elements to have this counter discourse on safety arriving at the EU level. But the problem is this work should not be only the local organization's duty. You still need EU institutions to take this part of responsibility. And if they keep focusing on whether we see more or less Europe rising after reforms and not which Europe we want, well, human and LGBTI rights are just going to stay secondary. And when you face long time ingrained biases, secondariness, I would say, is not enough for this change to happen. It needs more radical change, let's say. And that's it for me. A bit over time, but should be okay for some questions later.
Yes,
right.
Thank you very much, Amandine. This was really interesting. The concept of safe has been disturbing me since the beginning of the conference, and you have placed it in a great place. Thank you. So If you have any questions, please feel free to write them and we will get back to them at the end of Carmelo's talk. Our second speaker is Carmelo Danisi, a member of the SOGICA project's research team. For the project, Carmelo has analyzed the developments around SOGI Asylum in international human rights law in the Italian context. He is the author of a number of publications in the field of human rights law, especially in relation to non-discrimination and migration in the framework of the ECHR and the EU. In the context of the SOGICA research, Carmelo has developed a specific interest in the jurisdictional issues and the extraterritorial protection of human rights in the relation between refugee law and human rights, as well as in asylum procedures under EU and certain domestic legislation across Europe. Carmelo's talk today is bringing the topic of SOGI asylum claims to recent reality we are having. Any protection from abroad in times of pandemic and border closures, the roulette game of people suffering persecution in countries of origin and transit. Carmelo, the floor is yours. Thank you.
Thank you, Jade, for this very long presentation. So you think I'm all these things? That's very interesting. Thank you very much for this, for your introduction. And yes, I'm a member of the SOGICA project. So today I will share with you some of the data that we have collected in this 4-year project. So I can share the screen so you can see maybe the presentation, and then do you see it? Jade, do you?
Yeah, we can see it. Yeah, everything is fine. Thank you.
That's fantastic. So yes, basically I'm, as I told you, I have been working with SOGICA in the last 4 years, and of course today I was asked to present some of the data and of the research that we have made. And probably since we have really covered a lot of aspects of the SOGI Asylum, probably you don't expect such a presentation or such an analysis, because I will look at the moment, I mean, at the life experience of SOGI claimants before they arrive in Europe. So, and why this? I think there are 3 main aims for doing this. The first one, of course, is to present SOGICA research, but the other is to connect SOGI Asylum with broader debates in international human rights law and international refugee law, but also look, if we have time, because of course we have just 20 minutes, if COVID is impacting in a way in relation to all these border closures. And the idea of doing this is also to use SOGI Asylum to improve interpretation of international human rights law in order to use these improvements for, of course, raising the standards of human rights protection of claimants that are situated in a similar, they are similarly situated. So today, that's why I decided to focus on the protection from abroad, and how and if there is any way to use the data that SOGICA collected to maybe justify a right to legal entry to Europe in light of SOGI specific condition. And I do this also because our independent expert at the UN, he made very clear in his in the report that was issued last year that the trauma and the persecution suffered by SOGI claimants start well before the actual flight to safety. And the travel experience are also really difficult. And I really had the impression that this statement was confirmed by many of the people that I interviewed. So for example, I just would like to remind what Jasmine, a guy in Italy, told me. During the travel, he said, many people died in my presence. They killed somebody from my back. You see people die after passing through all this. You come here in Europe, and the commission, so the Italian administration, rejects your claim. If you are not strong, you will go mad. And that's why I think we should have a look at the experience in country of origins and in the travel and during travel, so in country of transit, in order to also make decision makers aware of the experience of SOGI claimants and why sometimes they are not even able to to talk about their trauma. And I really found this in almost all my interviews. So just to give you an idea about the data that I would use, you know, the Sojica project is a 4-year project, and the case studies are Germany, Italy, and the UK, but we also covered the European Union and the Council of Europe. And of course, one of the theoretical frameworks that we use is human rights. And so that's why I'm really interested to maybe use this data to raise standards in human rights law. So we have carried out more than 120 interviews, more than 15 focus groups, and we also carried out some observation in court. So all the things that I will say come from this fieldwork. So just to give you a few trends, if we think about the travel and the country of origin, in Germany we saw claimants from Asia, Africa, Middle East, Latin America, and many of them arrived in Germany via the Balkan route and the Mediterranean route. So very few with legal access, had a legal access to Europe. The same in Italy, or maybe even more, I would say, because most interviewees were men from Africa, so Gambia, Ghana, Ivory Coast, and all came through the Mediterranean route. In the UK, we had a more, I would say, broad range of nationalities. People from Asia, Africa, Middle East, talking about continents, of course, and some of them arrived directly to the UK, so they didn't arrive through the Balkan or the Mediterranean route. And what I was surprised is that Germany, Italy, or UK, they don't have humanitarian or admission programs addressed it specifically to SOGI claimants. So that's why most of them had to take a very difficult journey in order to claim asylum in Europe. And this is also because when legal channels to Europe are available, like for example, the possibility of family reunification, family reunification is based on a heterosexual notion of couple. So it's very difficult for them even to justify the request for family reunification because they don't have, fill the criteria in relation to come to Europe and avoid, through family reunification and avoid the journey. So just look at the data first, and then I hope we can make a reasoning about the right to access to a fair asylum procedures in Europe. So according to the Sojica fieldwork, I was not surprised because many people, they really didn't rejected their country. So they had many of them a feeling of loss. They didn't want to come. They were forced because of the situation. So and everyone, probably, I think almost everyone, focused on the social environment, not the legal discrimination, not the persecution coming from states authorities. So it's something very different. I mean, not totally different, but in a way, it's not really fit with the country of origin that decision makers often use. So there was always a reference to the popular justice. The experience of community discrimination, abuse, forced concealment, as we all know. But it was very interesting because if you look at these quotes, for example, Rosette said, in Uganda, you can survive. They will say that you have a demon. They believe that if they put a sword on you and cut and bleeding you, that the demon is getting out. That's what they believe. And, you know, I interview a decision maker who said that basically this cannot be true. It's a fake story because you cannot believe in demons. But put this quote in the culture of that community. In Nigeria, they look at you like an animal. So they describe this thing, you are an abomination to the land. And of course, the same thing came out from Momo. The same thing, I mean, the same kind of trends were confirmed by Alan A. coming from Cameroon, that basically he was saying, I lost everything. I had to go out from the country because I was hunted by people. Look at this other quote, for example, from Stefina. In Malawi, even the president says, we are like dogs that eat our own vomit. These trends were not reported only in relation to countries where there is a criminalization of homosexuality, but also in relation to countries where there are sort of protection, legal protection for SOGI minorities. So, for example, I remember a case from South Africa, but also a case from Russia. Russia is party of the European Convention on Human Rights. So basically it can be defined as a safe country, as Ahmadine would say. And as Alim said, I used to dismiss those fears and threats for a long time. By the end of a year, I felt I was no longer safe in Egypt. Why? Because some people entered in the grind charts. They discovered some people, and these people were arrested and then tortured. So that's why I decided I was not safe anymore in my country. If you look at the travel experience, this travel experience where, I mean, even some people, they couldn't even talk about that. It was a very source of trauma. Often they don't choose in which country they would like to flee, because as Alain said, if I remember well, it was Sheni, but it was something very common. I have to do it. I have no way. I had to go. And there was another guy that told me I was in a boat, but I didn't know if I was disembarked in Italy or Germany or whatever. It was just to go out of his country. So The problem with travel is that these SOGI claimants all told me that they need to cross states with similar levels of homophobia and transphobia. So of course, this is applicable, especially for SOGI claimants in Germany and in Italy. They need to travel. Often I had experience of more than 1 year with people that are themselves the agents of persecution. And they, of course, they need to conceal their SOGI. And most of them are even, are exposed to high risk to be involved in sexual abuses, economic exploitation. So at the end of the day, even all our interviews that were not, that are not refugees and asylum seekers, they really found that the travel is a synonym of violence and ill treatment. So sometimes the trauma is so big that they even restrain when they are in Europe to showing their feelings. I don't want to go into detail in relation to this because I think the idea is very clear. But if you look, and I will publish this presentation slide in the Sojika website, so you can have a look at it. But if you look at the experience even in transit countries like Turkey and Libya, for the Soji claimants that were there, this was a very, very difficult period of time. So the experience of economic exploitation and sexual abuse were really common. And some of them also were raped and, of course, and black males. So what to do with this data? So because it's very interesting, of course, to give you an idea of this. But I mean, can we use this data to justify the rise or of an individual right to request a legal access to Europe under international human rights law? Of course, the idea is to avoid the journey and also the abuse after being discovered. So the problem is that we have a very good piece of international human rights law, that is the right to access to a fair procedure, that is protected by the EU Charter, but also by indirectly, at least, by the European Convention on Human Rights. But then, so we should make something of this. But then we have the problem of the applicability of human rights obligation beyond Europe. So if human rights treaties are not applicable when SOGI claimants are in their country of origins, there is no point to say that European states need to grant legal access to Europe because they are obliged to do so under the European Convention on Human Rights. So in the last 2 to 3 years, there were some developments in relation to this issue. And I just briefly give you the names of these cases. So these are the X and X case, the Court of Justice of the European Union, and the case M and N and others against Belgium that is very recent. And both cases, both courts, they said that the human rights obligation for European states under the European Charter, the European Charter, the European law, and the European Convention on Human Rights are not applicable in country of origins of SOGI claimants. I mean, of course, of asylum claimants. These were not cases about SOGI claimants, but we can use these cases in order to reach a different position, I would say. Look, the problem, and I talk about the second case, was that according to the European Court of Human Rights, even if human rights are, of course, we know they are universal, etc., but there is an Article 1 that is the rule of the European Convention system is that the convention applies only in the country, in the European country territories. And in fact, the European Court said a positive finding on the matter of jurisdiction in a migration case involving embassies would imply the risk of a not agreed sort of universal application of the European Convention on Human Rights. So basically the court was saying even if a claimant goes in an embassy of a European state, we cannot apply the European Convention on Human Rights because the state has not, does not have physical control over the claimant. And of course, this prevents European states from being obliged to grant access, legal access to migrants. So my question is to conclude, I mean, to go towards my conclusion is, can we use the data on SOGI claimants that we have, that I showed you, to reach a different conclusion? So my answer is yes. And how we do that? First, we need to make clear that European states have they have a very false idea. Before the European Court of Human Rights stated European states, especially Belgium, fear that international human rights law is interpreted in a way to require legal entry to all persons living in catastrophic situations, or to everyone who might be exposed to torture everywhere in the world. And this is of course false, because even if you have an obligation to grant legal access, this doesn't mean that European states need to open the gates or the borders to everyone. So what I argue is that in light of the data that we saw, human rights treaties, and especially the European Convention, is applicable in the country of origin when a SOGI claimant needs protection, and how if the state has knowledge of the effect that a denial of entry has on a person's life. And this is supported. I will not go to the duty to prevention because I have to finish. But this kind of argument and is supported by some developments in the jurisprudence of other universal bodies. So if we look at the developments of the Human Rights Committee, you can argue that a decision of non-admission is an act of a state. So if a SOGI claimant goes in an embassy and is asked for protection, then the state can have a suspicion that considering the social discrimination that faced by SOGI minorities in that country, may raise a risk to violation of the right to life or the prohibition of torture. And this, if the states becomes aware that the decision of admission or not admission may impact in a direct and reasonably manner on SOGI claimants, and this is something that our data show, then the consequence is that the states have a duty to grant a legal entry to have the asylum claims, of course, duly assessed. Of course, the idea is to prevent further violations of the right to life and the exposure to torture, either in the country of origin and in the country of transit and during the travel. So to do this, and I conclude with our final call, I think that all the system needs to needs a shift from generalized assumptions on asylum claimants to their specific circumstances, and from general control over SOGI claimants to the effects that decision denying entry may have on these claimants. So to conclude, since legal entry is still a discretionary choice for states and not right for SOGI claimants, I think as SOGICA, we are right when we recommend the EU and European governments to start a humanitarian mission program. We should call NGO to maybe play a better role in demanding systematic admission and humanitarian programs. Maybe lawyers that are participating or activists, they can also bring or elaborate strategic litigation before human rights courts or even national courts. And of course, we all need to make a bit more of the right to access to a fair asylum procedure. So if you want, of course, to know more, go to and visit the SOGICA website or consult the SOGICA publications where these aspects were more broadly and, of course, explored in more detail. Thank you, and thanks for all the people that accepted to talk to me, and because they really hoped that they talk to me could help all the people coming to Europe and to have a fair procedure. But of course, now the problem is these people may be stuck at the borders of Europe, and we should avoid that. Thank you.
Thank you, Carmelo. We have listened to Dr. Carmelo Danisi from SOGICA Project, and this is our first speaker was Amandine Labellec,